So make sure they're ready to start broadcasting and recording. Thumbs up. Okay, good afternoon everybody. We will open. It's Wednesday the 27th of April 2022. This is a meeting of the Licensing Subcommittee of the Royal Borough of Kensington and Chelsea in the case of Tara Properties Limited, 1A Kensington High Street, W8 5NP. My name's Greg Hammond. I am Councillor for Courtfield Ward, which is the ward directly to the south of the ward that this property is situated in. I have no interest to declare, but I do know where the property is and I'm quite familiar with the location. I'd like to introduce my colleagues on the committee, so starting to my immediate right.
Hi, I'm Councillor Sof McVeigh. I'm a councillor of Brompton and Handstown, and I chaired the review of the JCO hearing, so I'm familiar with the premises and the issues of the previous operator. Thank you.
Good afternoon. I'm Councillor Pat Healy. I represent Dalgarno Ward, which is the furthest northwest ward in the borough, and I also was on the subcommittee that revoked the licence for Jacko.
Thank you very much. Now, we three are the decision makers in the case, but we have some assistants in the room, starting with our legal officer. Please carry on.
Hello, my name is Lindsay Lemazurier. I'm the legal advisor to the committee today.
Thanks very much. And then we have our licensing officer.
Thank you, Chair. Good afternoon all. My name is Paul Phelan. I'm the licensing officer.
Thanks very much. And I won't introduce everybody that's helping us from the administrative point of view, but we've got Luke there who's organising the broadcast and the recording, and Gareth, and I think there might be one or two other officers that come backwards and forwards from the governance team. So let's now introduce the parties. I'm going to start with the responsible authorities. We have the police.
Thank you. PC and Davis licensing.
Thanks very much, Constable. And we have the licensing authority.
Hello, Laura McGann from licensing.
Thanks very much. And noise and nuisance.
Good afternoon, sir. It's Keith Mahaffey from the noise and nuisance team.
Thank you, Mr. Mahaffey. And then our applicant, I understand, is represented by Mr. Butt.
Good afternoon, sir. Yes.
Thanks very much. Would you like to introduce the rest of your party if you've got others with you?
Yes, present with me is Mr. Browning, who instructs me.
Thanks very much, Mr. Butt. And then objectors on my list, I have Linda Hamilton. Thanks very much. I heard that. We'll come on to how you turn the microphones on in a moment. And then I have Eileen Rook. Hi there. Thank you very much. It's an introduction at the moment. So, Mrs. Rook, welcome. And then I have, from my new list, I have Marcus Lavelle.
Hello, sir. Yes, here on behalf of Sakura Limited.
Thanks very much. And Julian Steens.
Good afternoon, sir. Yes, I'm Julian Steens. I'm assisting with Mr. Lavelle.
Right, thank you very much indeed. So that should be everybody in the room. So the ground rules for working in here, you'll notice that this red light is on the microphone for those who are not familiar with the council chamber, and there's a button in front of you called request to speak, and that will turn the microphone on and off when you get to your speaking parts. I think we can only have 2 of these on at one time, so please leave the microphones off except at the point when you have a speaking part in the chamber. I think you worked out that we're broadcasting live and we're recording this, so you know. I'd then like to go through the documents that we've got. So the first one, we've got the main exhibit bundle, or the main bundle of evidence, which is 123 pages, and I'll call that one Exhibit 1. We have a 6-page document, which is the list of complaints in respect of JCOs, which arrived separately. I think it should have been part of the main bundle, but it's a separate document, so we'll call it Exhibit 2. And then, again, it should have been in the main bundle, but wasn't. We have the JCO conditions, which is Appendix 2. I think it belongs between pages 64 and 65 of the main bundle, but it arrived separately, so we'll call that Exhibit 3. And I think at midday today an extra document was circulated which the committee hasn't received yet, but we need to make sure that all the parties have had it. So we're shortly going to have a brief adjournment to read that, which Mr Butt very helpfully supplied. We'll probably have an adjournment in place to read that, so we'll come on to that in a moment when I make sure everybody else has got it. But before I come to that, I just want to go through the order of what happens once we get started. And the first thing I'll do in the hearing is to ask the licensing officer to outline the case. And then once Mr Phelan has done that, I'll be turning to Mr Butt for the applicant, who will have 10 minutes to outline his case. And then there'll be questions from members of the committee, the legal officer, the 3 responsible authorities and the objectors. And once we've been through that, each of the responsible authorities will have 10 minutes each, followed by a question period. And then each of the objectors will also have a 10-minute slot, plus questions from all the other parties. At that point, we'll have finished each section, each party's section. We'll then go through the potential conditions, which will be led by the legal officer. I won't have any summing up, and then we will adjourn to make a decision, which will be communicated to you within 5 working days. So that's how it works. But for those who are unfamiliar with licensing, I will be leading you through each section as we get there. Now I think we need to turn to this extra document. So who's got it? Mr. Butt.
Chair, I'm entirely in your hands as to whether we hand it out now or not at all. All this document is in written form the submission I'm going to make to you. There is, of course, no evidence in it. But given this is a little more complex than some applications, I thought it might be easier if everyone had a speaking note in front of them when I made the submission. But if you would rather it is not handed out, then I'm entirely in your hands.
Mr. Butt, I think it would be very helpful for us to have it. So let's hand that out, please, to everybody. Thank you, that's very helpful, Mr. Butt. I'm going to call it Exhibit 4, but as it's your speaking notes, I think rather than sit here and read it, I think we'll let you make your submission and then we can sort of follow it as you go through. And let me ask if anybody's got any other preliminary matters before we start. There's head shaking and silence, so I'm going to take that as no more preliminary matters, in which case, Mr. Butt, over to you to make your case. And you have 10 minutes.
Thank you, sir. This is an application by Tara Properties, the applicant, for a new premises licence at these premises located at 1 to 1A Kensington High Street. And the applicant, Tara Properties... Sorry, sir.
My apologies. I actually need to ask I didn't ask the licensing officer to make his summary. It's my fault and my apologies. But thank you very much to my colleagues for pointing that out.
Thank you, Chair. Good afternoon all. Today's application has been submitted by Tara Properties Limited for the grant of a premises licence at 1A Kensington High Street, London, W8 5NP. The premise is previously traded with a premises licence which was revoked at committee following a hearing on the 8th of February 2022. The current application mirrors the hours and the conditions of the recently revoked licence. A copy of this licence can be found at Appendix A, pages 13 to 28 of the main bundle. The current application before you today seeks the sale by retail of alcohol both on and off the premises and the playing of recorded music indoors from midday until 3 a.m. Monday to Sunday, the performance of live music and dance indoors from 9 p.m. until 1 a.m. Monday to Sunday, and the provision of late night refreshment indoors from 11 p.m. until 02:30 a.m. Monday to Sunday. Full details of the activities and timings sought can be found on page 2 of the main bundle. A full copy of the application has been included at Appendix B, pages 29 to 48, with the supporting plan attached at Appendix C, page 49 to 50. I can confirm that this application has attracted 3 representations from responsible authorities, namely the Metropolitan Police, the Licensing Authority, and Environmental Health Noise and Nuisance Team. I can confirm that the licensing team received 8 additional representations from residents, which also opposed this application. A summary of the representations can be found on page 9 to 11, with full copies attached at Appendix G, pages 68 to 78. A list of complaints received within the past 24 months has been made available to relevant parties and is available in paper format here today. Council records indicate that 6 temporary event notices had been submitted within the preceding 24 months. A list of these temporary event notices can be found at Appendix H, pages 79 to 81. That concludes a summary of today's application. I'll leave it there for now. Thank you, Chair.
Thank you, Mr. Phelan, and my apologies for my discourtesy in missing you out, and I know it's the second time I've done that in the last 12 months, so my apologies for that. Mr. Butt, now it is your opportunity to make your case.
Thank you, Chair. The applicant, as you know, is the freeholder of these premises, and the purpose of the application is to obtain what is sometimes referred to as a shadow licence to substantially mirror the terms and conditions of the existing licence, which in my document I refer to as the primary licence. Can I acknowledge at the very outset that these premises have had, to say the very least, a difficult history, and that the applicant will need to address that as part of this application? As you have heard, the primary licence held by Sakira was reviewed on the 8th of February 2022, interim steps of suspension having been imposed, and that licence has now been revoked, albeit the licence holder awaits the formal decision notice, and it is likely that that will be appealed by Sakira. Meanwhile, the applicant has served a forfeiture notice upon Sakira and has possession of these premises, though that order is understood to being appealed to the High Court at present. So if this application is granted today, there will of course be a time during which both the primary licence will exist, possibly subject to an appeal, although with the interim steps imposed, and also this licence will exist if you decide to grant it. The concept of shadow licenses will be familiar to the committee and in particular to the legal advisor. In essence, the High Court has held that there is nothing wrong in principle with, in particular, a landlord whose only connection to the premises is owning the premises and collecting rent in relation to the premises, in holding a license because that person is concerned with the running of the premises, which relates to licensable activity. In fact, in a case such as this, where the license has been revoked, the landlord has taken possession, and the landlord's intention, if this license is granted, is to operate the license or to find a tenant to operate the license, then in fact, Section 16 of the 2003 Act could be complied with, either on the basis of current use or on the basis of proposed use. But there is no dispute, it is thought, between any of the objectors or the responsible authorities that, first of all, more than one license can run concurrently on premises, and secondly, certainly in our submission, that Section 16 could be complied with, either on the basis which we've set out within our application, our paragraphs 7 to 12 of current use, or in relation to proposed use. As I said at the outset, we acknowledge, to say the very least, the unacceptable history of these premises. And for the avoidance of doubt, in the event that a licence were granted to the applicant, it would not be possible for Secura to operate the licence. We would not allow that, and we propose a condition that will prevent that from happening. Whilst this application has been made with the intention of mirroring the conditions of the existing licence, we accept that the history of the premises would suggest a need to modify the proposed terms in line with the Council's statement of licensing policy in order to ensure that the licensing objectives will be promoted. At paragraph 15 of our application, we've set out 4 primary differences between the current licence, subject to being revoked, and what we are in fact asking the committee to grant today. The first significant change is that we would request a terminal hour of 1 in the morning, and that would relate to the sale by retail of alcohol and regulated entertainment in relation to recorded music only. The second, primarily to deal with concerns raised by the responsible authorities and residents about behaviour outside the premises, is a last entry condition of 11 p.m, save for those who have left temporarily to smoke. The third is we propose a condition that the tenant, which would be the individual who operates the licence, ought to be approved by the police. And the fourth is that we would propose that all conditions currently on the licence would remain on the licence, subject to a revision where those conditions are no longer applicable due to the earlier terminal hour. What we have tried to do, sir, by setting this out in writing before the hearing, is not to approach this as a form of a negotiation, but we've tried to look at the representations, both from the residents and the responsible authorities, and ask ourselves how these premises can have a licence as a final position, which would be both commercially viable and would promote the licensing objectives. If I can turn then to the representations in turn, and first of all that which was set out by PC Davis from the Metropolitan Police Service. PC Davis says in his representation that JACO became a poorly managed destination location which impacted on the licensing objectives and invariably questioned the tenability of such a late operation for this area. Inasmuch as that relates to how Secura operated the premises licence, the applicant does not quibble with that statement. In order to assert better control over the premises, the applicant proposes initially the 11 p.m. last entry condition, which would assist to address the concern in relation to this becoming a destination venue. We would have thought primarily that would bite on Friday or Saturday nights, but we would agree to this being opposed 7 days a week if the committee would prefer. We would also submit that an earlier terminal hour of 1 a.m., both for alcohol and for entertainment, would significantly reduce the negative impact of the venue's perceived destination status, as would limited regulated entertainment, only recorded music, and subject to the conditions proposed by the Environmental Health Officer. As to the police concerns about how the premises were run, we accept that the evidence heard during the review hearing speaks for itself, and we accept that this must change. The applicant therefore proposes a condition to be added to the licence to provide some comfort to the committee and the residents and the police in relation to who will run these premises in the future. The proposed condition is set out at paragraph 21 and could be phrased thus: the premises licence shall not take effect until, first of all, the proposed tenant and/or holder/operator of the licence, and 2, any new DPS has been approved by the police, and that will be required for any subsequent change of tenant and/or holder of the premises licence. We note at Appendix M of the bundle there are a number of late-night premises in the vicinity, including Percy's, the cocktail bar opposite, built into the hotel. We also accept that these premises are different in their nature to a number of other premises in the area. All we ask in that regard is that the committee bears that in mind when considering statements, first of all, about whether the area is suitable for late-night venues, and secondly, in relation to these premises in particular, which of course have the necessary planning permission for the use which we request. All of the police conditions that are proposed, we agree, save for a caveat in relation to condition 1, which in effect is a restaurant condition. These premises are entirely located within a basement. There is no natural light within the premises. A restaurant condition as proposed by the police would be no and impossible for the premises to operate with. All that we ask is for a little more flexibility, and in that regard we would propose that the existing condition 39 be imposed upon the licence. That condition allows for 20 people to stand in the bar area in relation to private functions, and the licensing officer makes the very good point, well, what do you mean by a private function? We would interpret that as meaning a function that has been booked in advance. In the written document we've proposed 9 p.m. on the day of the activity, it could be 24 hours in advance. Obviously, they need to be bona fide private functions and not some kind of a dodge, as might have been the case with other premises in the past. We also propose a reduction in capacity to 150, which would further limit the potential impact of the premises. In terms of the licensing authority, a number of matters have been raised concerning noise from customers upon arrival and dispersal from the premises, in addition to the use of cannabis in Kensington Court and fighting outside the premises. Assuming for the present purposes that all of those matters are attributable to these premises, we would submit that the earlier terminal hour and the restrictions upon regulated entertainment, in addition to the other proposed conditions, would attract a different and younger clientele who would not engage in behaviour such as this. In essence, if the application were granted as requested today, this would no longer be a nightclub. We of course note paragraph 8.9 of the Statement of Licensing Policy and the concern raised by both the police and the licensing authority in relation to hours. The committee will note all that we are requesting is 1 additional hour and a modest extension beyond framework hours. And we rely upon the fact that this is not, however it's viewed, a standard application for a new license. This would mirror or replicate or shadow the existing license, and neither could there be 2 premises running at the same time if the license were granted. We note the matters raised by environmental health. All of the conditions proposed by environmental health are agreed. Paragraphs 30 to 32, I briefly addressed section 177A of the Licensing Act. It would not impact upon the proposed conditions. I can see, sir, that you're looking at your watch.
I am looking at my watch, Mr. Butt, because I've allowed you 11 minutes, which is, but of course we are supposed to have 10 minutes each, and I do need to be fair to all parties. But it is important that we understand what you've got to say. So perhaps if I can open some questions by saying you've got some observations on what the local residents have said, and I can perhaps do it in the form of some questions.
Of course, yes.
And, which I will ask to start with. And then
you're going to
I'm just going to ask a few questions to allow Mr. Butt to make his main points, and then I will... It's been 11. Please keep going. Yeah, so your observations on local residents?
Well, the first thing for us to do is to apologise to the local residents, because anyone who reads those representations will be left in no doubt about the problems that there have been in these premises. We would try to assure them that we are doing everything we can to ensure that the past operator will not be running these premises again. One of, but not the only, concerns raised by local residents relates to noise nuisance from the premises and the impact of the noise from regulated entertainment. The primary way that we propose to deal with that is by restricting entertainment at the premises only to recorded music. But we have also agreed all of the conditions proposed by environmental health, and that would include these premises will not operate until there has been remedial works in the premises in order to address problems of the party wall. It would also mean that there could be no recorded music from the premises until a sound limiting device had been installed and agreed at a level with environmental health. These premises should be able to trade without causing disturbance to local residents. It is unacceptable that has not happened in the past, but we hope that the committee can accept that if we do agree the stringent conditions proposed by environmental health, that would enable us to do so.
Thank you. And we also have some, I noticed might have wanted to said something about Sakira limited submission, and maybe give you a chance to comment on that as well.
They are skeletal submissions from Sakira. Without being rude to the previous tenant, we would hope the committee can see them as being entirely self-serving statements. To the extent that they raise concerns about noise breakout and crime and disorder, it is surprising to hear such submissions from the mouth of the previous tenants, given what happened in the review and the stance they are likely to take. In relation to Section 16, we've set out in writing how this application clearly complies with Section 16 of the 2003 Act. Nothing has been set out in the representation that seems to cut across that.
Thank you, Mr. Butt. I think we've heard everything that was in here now, and I think we now need to ask my committee members to ask some questions. So, Sophie, do you want to go start first? Councillor McVeigh.
Thank you, Chair. Thank you for your submission. Very useful and significant changes to the application. It would have been nice to have had it a bit earlier, I think, for all parties. Having sat on the review, one of the main concerns was the management, and you obviously chose them as your tenants. So how can we trust that you are going to actually do a better job next time?
Can I first of all make the obvious concession that is an entirely fair criticism to be directed at the applicant? We had no role in running licensable activity at the premises. We should, as the landlord, have been more aware of those problems. In fact, we own a number of residential premises close by and linked to the premises, and the proposed DPS lives very locally to the area. It is in the applicant's interest, as much as anyone, to ensure that these premises are able to trade compliantly and lawfully and without causing disturbance to the local residents. So we would ask you, first of all, to take our assurance in that regard. The responsibility, of course, lies with the individual that conducts the licensable activity, and in the past that wasn't us. All we can do to try to assure the committee that if this licence is granted, there will not be a repeat of what happened in the past, is to refer to the condition we propose that the police will be able to approve the tenant and the operator of the licence.
Thank you. I just want to follow up on that. I thought normally it was the licensing authority rather than the police that did that. Is that, so we just bring in PC and Davis here, or Mr. Phelan, just to...
Yeah, to answer that question, it's a bit of a difficult one and a subjective one. If we're going to be saddled with the responsibility of saying yes or no to a prospective tenant, we would normally do research via our indices, which is subject to Data Protection Act, whereby if we identify, say, an assault at another premises, is that significant enough to see how it's managed? I'd be a little bit more reticent as into not agreeing that condition, because it's and also from the fit and proper aspect of it, it'll be a difficult one for us to do, and it's quite an unusual one. Thank you.
Thank you, Councillor. Essentially, you sort of reiterate what PC Davis has said. It's not something that we would look to approve, essentially.
Can I... The condition that's often put onto a shadow licence is that in the event the licence be surrendered or revoked, there will be a 30-day cooling off period before a new tenant or operator takes over the premises, and the purpose for that is to enable the responsible authorities and the police to express any concerns that they have. If this condition were placed onto the licence, and it obviously can be tweaked and changed, what it would certainly ensure is that there would be a clear dialogue between Tara Properties and the police. So if the police had any concerns about the new tenant, they could be raised with us. Whether or not it's fair to place the obligation upon the police to approve the tenant, I entirely take PC Davis's point. But what we would certainly want to do is to assure the committee that we are not going to appoint a new tenant without discussing it with the police and seeking their guidance. The other reason for that condition is what it would enable the police to do would be to prevent Sakira from becoming that tenant. So the principal reason for putting that onto the license was to assure the committee that we weren't going to have a license granted to us and then allow Sakira or another version of Sakira to be installed as the operator of the license. It was primarily to prevent that from happening. Equally, that could be done by stating...
Okay, understood. Thank you. If the committee were minded to grant, we'll probably take legal advice on this. But thank you for clarifying that. So my question about the tenant is noted. Thank you for that. And thank you also, just to confirm, so you're reducing the capacity to 150, and obviously the restaurant condition you're not keen on. Okay, and have you reached out to some of the local residents recently?
Because of the nature of this application, which I accept is very unusual, it is, on one view, a shadow license. On another view, it is a reflective license pending the resolution of the appeal. We have not, as the landlord, consulted with local residents, no.
Okay, thanks.
Councillor Healy, please.
Could I just follow that up? I understand entirely why it has not been felt appropriate at this moment in time. But in future, given the extent of objections from residents both today and at the review hearing, would you ask any tenant that you offered it to have some kind of commitment to having communications with residents so that they do actually understand that you're trying to run something properly?
We absolutely have to do that. And in fact, PC Davis has proposed, it's at page 57 of the main bundle, condition number 6, which would require there to be meetings between the premises, ward councillors and local residents.
Sorry, I know jumping around. Sorry, I just want to follow up on that. Completely understand that. We're aware of that condition. It's a standard condition pretty much for applicants these days. But you as the landlord, what are you going to be doing if there needs to be a bridge between residents, say, and another operator potentially? You know, are you just going to wash your hands of this as soon as you get another license on operator?
We absolutely will not be washing our hands of it because we are aware that we are already beyond a perilous state where these premises could be left without a license. And we are in no doubt that if there is a repeat of what happened with Sakira, and if, heaven forfend, we found ourselves in another review hearing were the committee to grant today, then that would be an end for these premises, which are not really commercially suitable for any purpose apart from holding a license. So we most certainly would remain as part of any ongoing dialogue between the operator and the local residents.
Okay, thank you. In your submission, the written one that you went through, you suggest that the earlier terminal hour and the last entry condition will result in an older and better behaved clientele. This is surely pure supposition.
It enables you to control the premises far, far better. It means that we will not be in the market for people who have left premises after conventional closing times and are then just moving on to the next club. Also, if condition 39, which is the condition requiring that patrons either be taking a table meal or be limited to 20 at the bar, or a pre-booked private function of 150 is properly applied, then really those who are coming to the premises for anything other than a table meal ought to be known to the premises in advance by virtue of the pre-booked function. So we would hope that a combination of an earlier closing time, last entry at 11, and proper administration of Condition 39 would not attract the kind of clientele that were involved in the most recent incident that underpins the subject of the review.
This is not strictly a licensing issue, but given that the kind of clientele who were attending previously had been largely attracted by online advertising, which perhaps gave a misleading idea of what the premises were for, would it be your intention to ask any tenant that you were considering that they would not use such means to attract clientele?
Absolutely. And if you're referring to promoted events, I think there is a proposed condition in any event there be no promoted events at the venue.
Okay, thank you very much.
Thanks very much. I've got a handful of questions remaining, and I think first one, I just want to understand a bit of the history of Tara Properties' ownership of the site. How long have they owned it?
I'm afraid questions in relation to the ownership of the property would have been answered by Tarek. Unfortunately, his wife is having a baby as we speak. He was due to be here. He isn't.
So, well, perhaps I'll try another one. Were along the same lines, do we know if there were any other tenants other than the JCO operator under the ownership of Tara?
I don't think I'm going to be able to provide an answer that's helpful. There certainly were previous tenants to Sakira, but the chronology we do not have to hand.
Right, okay. Well, we might ask some of the residents what they remember if it's helpful for background. I had a series of questions about conditions, but I think you've helpfully been through those, Mr. Butt, to sufficient detail, and we'll have another section in this meeting to go through them in more detail later on, so I can park them. I'd like to ask about the current licence has an off licence as well as an on licence. Is that something that you're applying for? It seems rather peculiar that you're applying for an off licence for this site.
That would not cause any concern to the applicant. There is no part of any responsible future business model is going to realistically involve off sales, so no.
Okay, thank you. And I think we wanted to know a little bit more detail about the physical location of the smoking area and bar area as well. And I'm not sure how we're going to be able to do that in this room. Have we got a excellent. The licensing authority's got something. So I think this is something we need to ask you as the applicant to go through with us. So we've got another document to hand out. Thank you. So we'll call this Exhibit 5, as it's a map, and we'll just wait for it to go round to everybody. I'll ask these questions. So let Mr. Phelan return to his seat. And I'm holding this the right way up with the writing, although it's quite small, so I can see it at the bottom. So if somebody can explain to me where the front of the premises is it at the bottom of the page or the right-hand side of the page or the left-hand side of the page?
So the front of the premises must be where the ground floor entrance is at the bottom.
I see, yes.
And that leads on to Kensington High Street. And then there is, in front of the premises, at basement level, a sort of small fire escape area. One of the problems with the licence is that the condition makes reference to smoking in the designated area, and the plan does not specify what the designated area is. The condition is for those who leave the premises, and realistically they are going to have to do that because they can't smoke within the fire escape. Absent a designated smoking area at the moment, that is something would have to be agreed. So I would ask a condition be added that the location of the designated smoking area must be agreed with the responsible authorities in consultation with residents, as would a limit on the number of people who are allowed to use the smoking area. It's going to have to be at the front of the premises. It's going to have to be a small number of people. It's going to have to be well controlled by SIA security at the front.
So there isn't a second space somewhere else on here? I mean, there seems to be some sort of fire exit or some kind of exit to the right-hand side of the page, but whether that's...
There is a fire exit at basement level.
Yes.
I cannot see how that could lawfully be used as a smoking area. If it was, of course, that would create no difficulty because patrons wouldn't be leaving subject to noise being controlled, but realistically, that would not be compliant with health and safety.
And that does appear to back onto Kensington Court, but I think you've been very clear about the proposed condition on that subject. And can you also help me with where the bar is in here, please?
I'm afraid I can't. That is also something which needs to be amended because a condition requires that people be within a designated bar area that is not marked upon the plan. So this plan needs to be updated in order for either the primary or the proposed licence to be compliant with the conditions.
Right. Thank you for that. Let me just turn back to my colleagues to see if they have any further questions. No? No. Pat? Nothing more. Very good. Thanks very much. So I'm just going to ask our solicitor if she has any questions.
Thank you. One or two questions. Just for clarity, can you confirm that you are no longer seeking live music indoors?
That's correct, yes. The only entertainment that we seek is recorded music.
So it's just recorded music, no performance of dance, no late night refreshment?
Late night refreshment would be as per the application, but obviously scaled back to...
Fine, sorry, yeah.
I think 1:30 a.m, given the existing licence places a prominence on the need for food to be available.
Okay. And you said just now that you'd be happy for off sales to be removed from the application. Thank you. And I don't think there's an existing condition regarding capacity, but you've confirmed 250 down to 150.
Yes.
Thank you. That's all I've got to ask.
Thanks, Mr. Mazurier. I'm now going to ask the responsible officers in turn what questions they've got. So starting with PC Davis, please.
Thank you, Chair. I've just got one question. I appreciate it's a difficult one for Mr. Budd to answer because the applicant's not here. But just for clarification in relation to the engagement between the landlord and the tenant, and also moving forward with any other prospective tenants, what sort of engagement with the tenant did the licensee? This is more of a question for the record. Simple reason because obviously the review happened, but obviously there's kind of been a bit of a build-up for the preceding years, etc. And it seems to me that stuff could have been mitigated a lot earlier. Thank you.
There's nothing I can really say to assist my client's cause in relation to what's happened in the past. Obviously, to the extent that a landlord has responsibility for what's happening, has a commercial interest, it would have been in our commercial interest and in the interest of the residents for us to have taken action sooner. We can certainly look to ensuring that the lease As I mentioned, the existing one probably did. That's just speculation based upon commercial leases generally. Would probably have a clause about not doing anything that would jeopardise the premises licence. But as to what happened in the past, I can't really assist.
Thanks very much. PC Davis, anything else?
No, thank you. That's all. Thank you.
Thanks very much. Mr McGarn, any questions from you?
Thank you, Chair. I've also got the same issue that my questions are more for the landlord, the actual applicant, and I don't know if you'd be able to answer them. You have mentioned earlier the new operator and the new clientele, and I think a councillor discussed it, raised it as well, but we don't, our real concern is we don't know who that applicant is, we don't know who that operator will be, we don't know what type of clientele will be visiting the premises. So I suppose my question to you is, how will this be vetted? I know we've spoken about it a few times. This is our main concern.
So there are 3 points in that regard. The first is, this would be akin to a shadow license. So it is not unusual that a premises have a license that envisages someone else will come in to operate that license in the future. So the position of not knowing necessarily who will run the premises is not by any means unheard of or forbidden. In terms of how we will ensure who the clientele will be in future, all that we can do is point to conditions on the license, hours of the license, and what entertainment will be offered. And our submission is, with the earlier hour, re-entry condition and limited entertainment, it is simply not going to be marketable as a premises that's going to be a late night destination venue, nightclub style operation, especially with the sound limiter, with limited regulated entertainment, and with the proper application of condition 39. In terms of vetting, I entirely take the point about what PC Davis said. We will liaise with the responsible authorities as to who comes in, but ultimately, we and they need to ensure that the conditions are complied with and the life of the object is promoted.
Okay.
Anything else, Ms McGarn?
Yes, just in regards to conditions on the licence, I know we will go through the conditions in some detail, I'm sure, but again, this might be difficult for you to answer. There's a number of conditions on the licence that are there for good reason, because the residents have had so many issues in Kensington Court and they were not complied with by the previous operator. And they're in regards to a parking valet service, chauffeur service, free overnight parking. I'm just wondering how your new operator of the premises will be able to comply with these conditions.
The short answer is they'll have to comply with the conditions. And they come at a commercial cost. And the agents who are acting on our behalf to find a new tenant are aware of the requirements of the premises. They are aware of the need to ensure that disturbance is not caused to the neighbours, and they are aware of the fairly onerous conditions already on the licence and those that we are proposing in the future. So it's going to be attractive to only a relatively small number of operations.
Okay, so will it be up to the new operators going in to be able to look for these services then, for a valet service, for overnight parking within Kensington High Street?
They will have to comply with the premises licence, I think is all that I can say. And it can't be regarded as optional.
Okay. Thank you.
Thanks very much indeed. Mr Mahaffey, any questions from you?
Mr. Chairman, I don't think I have any questions.
Thanks very much indeed. Now I'm going to turn to the objectors to see if you've got any, in turn, to see if you've got any questions for the applicant. And this is questions to the applicant, not the opportunity to make your case, which comes later. So the order I've got is Ms Hamilton first.
Well, our objections, the residents' objections, are basically the same as they were before on the 18th of February, on the 8th of February. The noise nuisance, the antisocial behaviour, and by their own admission, the landlord
could I just stop you and ask you to pull your microphone towards your mouth? That's better. And it needs to be a question for the applicant, not a statement of your case at the moment, which you've got the opportunity to do later.
Okay. Well, the smoking outside is going to be a problem. I mean, there is no room, really, is there? That piece, there's a sort of pavement area. I imagine only 2 people can be in it. Is that going to be expanded, or you're going to allow people out onto the pavement to smoke, and crowds will be out there?
So the question is about the smoking area. If you perhaps expand on your earlier answer, Mr. Butt, on that?
Ms Hamilton is entirely right. It's a limited area at the front of the premises. It's a sensitive area. As with any premises, the risk of people coming out of a loud premises, standing outside in groups and smoking poses a real risk, and it's something that has to be controlled. The primary means of control is limiting the number of people who can be out there at any one time. And I think the better way to do that is to agree that with the responsible authorities in liaison with the residents, because it's a lacuna in the existing licence, and also, obviously, drinks shall not be taken out to the smoking area. But it's going to have to be at the front, and it's going to have to be a very small number of people.
Would you consider making the whole area, the whole premises non-smoking?
The premises are non-smoking. All licensed premises need to deal with the question of where patrons go to smoke outside.
Well, I just don't think you have enough room for that.
So this is a question opportunity, please, Ms Hamilton. Do you have any other questions that you want to ask?
Well, how do we know? I mean, basically you said that you didn't know what was going on when Sakira were running the... how will you know what's happening if somebody else takes on the licence?
It is a humbling admission that we did not keep a proper eye upon our tenant. I understand entirely why the committee and why residents are going to be somewhat cynical about what we are saying and our good intentions here. All I can say is the commercial interest of the landlord to make sure this kind of thing never happens again is going to be the cynical reason to do it. But I also have absolutely express instructions from my client that they want to ensure this never happens again. So I'm afraid the cynical motive of commercial imperative and our promise to you that we do not want this to happen ever again.
Can I speak?
Let me just, Ms Rook, hang on, Ms Rook, please. It's Ms Hamilton's turn to ask questions. I'll be coming to you in a moment.
It's all right. It's just relevant.
Ms Rook, just stand by. Ms Hamilton, do you have any further questions?
I don't have any further questions.
Okay, in that case, Ms Rook, it is your turn. And you've got a microphone in.
I'm ever so sorry, I'm a bit deaf now, post-COVID.
Rook, if I could just ask you to turn the other microphone on. There's one in front of you which is bent round away from you, and then you might find that easier to use.
And then press that.
And
no, that button, no.
Ms Hamilton can turn hers off.
Yeah. Thank you.
Your question then, Ms Rook.
Well, I feel that you did know what was happening there, because I and another tenant went to the planning permission meeting on the 6th of July, and we begged that the upper stages of 1A and 1 Kensington High Street not be started until JACO was sorted out the noise. And there were 2 councillors at that meeting. There was also a legal representative. I said it has been an absolute nightmare living behind this premises. And they said that they would inform you. So I can't think how you didn't know.
So this does need to be a question, Ms Rook.
Worse.
Ms Rook, this does need to be a question, not a statement.
That's a statement.
No, it needs to be a question. So if I could perhaps turn it into a question, and if I can turn that into a question, so you, Mr. Butt, you've heard a statement from the objector. What do you say to that, please?
I can only apologise.
Your solicitor, your representative, said that they would inform you. So nothing happened. It got worse. People got stabbed. So my question is, I can't rely on you saying you'll have control over the person, or how can you convince me you'll have control? There's the question.
Thank you very much.
All I can say is my client apologises and refer Ms Rook to what I've said already.
Right.
And I understand her position. Thank you.
3 stabbings after that.
We understand. Thank you. We do understand.
Ms Rook, do you have any further questions to ask? You'll have a full opportunity to make your statement later.
Thank you. Sorry.
That's right. You have a full. Don't worry. You have a full opportunity to make your statement later on, and this is just a question time at the moment. But Councillor McVeigh has a question. She wants to intervene before I come to the final objector.
Thank you, Chair. Yes, we will, if the committee were minded to grant any form of licence, we will have to really look at this, because this is a significant issue of trust, and it's, you know, words come easy, but actions often don't necessarily follow, so we'd have to look at that significantly. But the other thing, in terms of the acoustic sound, which I'm sure Mr Mahaffey will talk about at some point, the acoustic aspect to the premises, irrespective of whoever you get in to manage it, can the landlord guarantee that they will do the works rather than leave it up to the potential operator?
We could make it a term of the lease. So the tenant would be in breach of the lease if this were not done.
Okay, so you're not really putting your hands in your pocket for this one, are you? No. Okay, we'll discuss that with legal. But it seems, okay, it becomes a planning issue rather than a licensing issue, and we're a licensing committee, so...
And I can take instructions on that particular point and come back to you before the end of the hearing.
Yes. Thank you.
Okay, that was all from you. Yeah, brilliant. Okay, so let me turn to Sakira Limited, and Mr Lavelle or Mr Steens, which one of you is going to be asking questions, or are you both going to?
That would be me, sir.
Yeah, please go ahead.
Thank you, sir. I appreciate it may be difficult for my questions to be answered as the applicant isn't here, although we understand why one of them can't be here. It is disappointing that perhaps there aren't other people connected with the business who could be here. My first question is, I think it's one of the comments from the applicant that they're currently looking for an operator, and that operator will be then subject to various requirements and restrictions. Can I just check that's the case?
Yes.
Is my learned friend aware that his client, the applicant, has given an undertaking not to market or approach other persons to take on the premises as a part of the dispute that they're currently in with Sakira Limited?
I don't think the niceties of the legal dispute between Sakira and Tara Properties is relevant in relation to licensing issues.
Sorry, can I just check the learned friend's position on that? Your comment to the members is that your company, your client, is looking for a new operator, and it is not relevant that at the same time our position is that your client has given an undertaking, and of course I can't check with the client because the client isn't here. Your client's given an undertaking specifically not to do that. And that's a formal legal undertaking.
As I say, the committee is interested in the licensing objectives. I don't know about the niceties of the landlord and tenant dispute, but they are not relevant to the matter for determination today.
Yeah, and I don't think we can pursue this that line any further.
Certainly, so I may have something to say about that, though, in my substantive submissions. Though, so.
Yes, we get to that. Do you have any further questions, Mr Steens?
Sorry, I'm Mr Lavelle.
Sorry, Mr Lavelle. Do you have any further questions?
Not that I feel would be able to be answered, given what my learned friend has told me, the extent of his instructions are. So no, that's all we have to ask, sir.
Thank you very much indeed. We're now at the end of the applicant's submissions and questions, and we're going to turn to the responsible authorities in turn. PC Davis, please. You have 11 minutes to make your statement, and then there'll be questions.
Thank you very much, Chair. Thank you very much, Mr Butt. In relation to the police position for this application, I think a question is that, from my understanding, an adjournment was not requested by the landlord, because we seem to be filling a lot of vacant questions that could have been answered by him or representatives, and this is no slant on Mr. Butt and his position. Further to the additional reduction in hour down to 1 o'clock, there would be concerns in relation to dispersal and the retentions of members of the public in the local area. We have noted at the hearing that the Secura at the time had changed security a numerous amounts of times. Fair enough, there was a certain demographic that was causing the issue. However, their powers are limited to certain areas, and where a lot of these patrons end up kind of waiting for cabs and whatnot, tends to be in the back streets. The key police position in relation to this is around the prevention aspect, clearly. And as been detailed in my submission, the police are in full support of the midnight policy, and also in relation to the conditions that have been submitted, and namely that condition 1, which the police feel that would kind of mitigate any sort of issues in relation to patrons attending. Mindful, the licensing objectives do cover crime and disorder, so the financial aspect of it is quite a subjective matter. I'd like also to reiterate that not only are all responsible authorities here, enforcement, noise and nuisance, but also the residents are here making representations in relation to this application. I'll quite happily take any questions. Thank you.
Thank you very much indeed, PC Davis. Any questions? No questions for PC Davis from...
Actually, yes,
Councillor McVeigh, you do have a question.
I do have a question. Sorry, I just had to ask about the adjournment point you raised there, but that's a non-issue. Sorry, as far as we're concerned, but it is relevant that you raised it. Thank you, PC and Davis. A question about what you've heard today from the applicant in terms of his significant amendment, their amended ask, so to speak, up to 1 a.m. and the kind of the 11 p.m. opening hours from a police perspective. What is your opinion on that, please?
What's being proposed does address the crime and disorder issue, as long as you've got the right operators inside the premises and the right demographic and the right fabric of how they're managing the premises. It's quite an in-depth set of conditions, and I accept that Mr. Butt in relation to enforcing that in relation to any new tenant. However, the tenability of the 1 into 2 o'clock people hanging around is not far off from the 3:30 that was there before. So it's not a massive step aside from what was before. I think that is my response in relation to that, Chair. Thank you.
So, let me see if Councillor Peely has anything to ask. No. I want to just follow up on that, PC Davis, because between the three responsible authorities, you have slightly different takes on the proposed terminal hour, and of course we've heard another one today from the applicant. So you think, if I've interpreted that right, you would be happy with 1 a.m. as long as there were appropriate conditions in place?
The police position is in relation to supporting the midnight policy, which the police feel is proportionate for that location. My position in relation to if the right operator, it's nothing inconceivable to say that a 1 o'clock licence could work, but our primary position would be the midnight policy, hence we'll be guided by the committee in your decision processes in relation to that.
So as we don't know who the operator is going to be, then you're saying midnight. And are you saying midnight as the terminal hour or midnight for the cease of sale of alcohol?
Terminal hour.
And would you be saying cease of sale of alcohol earlier than that, or would you be saying both at midnight?
We'd be guided by the committee in relation to the seizure of sale of alcohol, but preferably before midnight.
Right, but midnight is your position on the terminal.
That's correct.
And your position to us is that it's not an outright, to us, your pitch is not an outright refusal. You're saying that with a midnight it would be acceptable to grant this.
That's correct. That's correct.
And 1 a.m. with the right operator, which obviously is the missing piece of the puzzle here, potentially.
Exactly, and
But, yeah,
obviously the difficulty installing the right operator is going to be subjective, and there's going to be a time frame of them proving themselves. They might be able to prove themselves in a different borough, different circumstances, different demographic, but RBKC is quite unique. And as I've always said, as I've represented licensing for over a decade, it's a privilege to have a licence in this borough.
Thank you, PC Davis. That's the questions from the committee. I'll just ask the legal officer.
No questions from me.
Thank you very much indeed. And we will go to the applicant, see if you've got any questions for PC Davis. The other responsible authorities, Ms McGann, Mr Mahaffey, and objectors, starting with Ms Hamilton. Ms Rook, any questions for PC Davis? Yeah, any questions to the police officer? No problem. And Mr Lavelle? Any
Toby,
questions?
sorry, sir, I was just trying to get the actual wording, sorry, from my learned friend's submissions. My question just for the police is, I think we heard him effectively explain that when he asked some questions. You've said potentially with the right operator, you could support something past the midnight policy. Are you given any security by the condition put forward by the applicant that you would effectively sign off or approve any operator? Would that give you the security you need to suggest that a licence past the midnight policy could be something that would address your concerns?
I think not all the committee members heard the question. I wonder if you wouldn't mind just the last bit of it, speak into the microphone so we can hear it, please.
I am terribly sorry, sir. I believe it's page 4, paragraph 21 of my learned friend's written submissions. I'm just asking the police, there's a condition there that effectively states that it's for the police to approve any future operator, and I was just wondering if the police could explain whether or not they feel that that would warrant the grant of a 1 a.m. licence and address their concerns on that if they were to be given some form of approval of the operator that ends up being put in under this licence.
Let's have the legal officer, please.
Thank you. I think the condition is really aimed at the licensing authority rather than the police having to object. I know you mentioned the police could be consulted rather than having the final say, but really it's for the licensing authority to this condition to be aimed at. That would be my view rather than the police, although the police can have some input into it.
Could I just note, sorry, I hear your legal advisor's words. The wording of the condition as proposed, police approval shall be required for any subsequent change of tenant. So that is the condition that's put forward. So I just wanted to know if, just on those grounds, whether the police would feel that would address their concerns. And in line with what your legal officer has said, I would suggest that such a condition cannot, I would suggest, be put forward in any event, as it abrogates the requirements for this committee to be satisfied of any particular operator, rather than simply the police. But even at its highest, I would just ask the police whether that would address their concerns.
Well, let me ask the police to answer that and give us a comment, please.
I think I responded to that question initially, whereby it's an unusual condition and it would be extremely difficult for us to kind of subjectively assess an operator and to quantify whether they are viable, whether fit and proper, etc., etc. So I, with all due respect, would be opposed to that condition. Thank you.
Any further questions, Mr. Lavelle?
other than to just ask if the condition itself wouldn't deal with it, the absence of the condition, I anticipate, does nothing to support a request for a 1 a.m. in your eyes? That's just a further question for the police to clarify.
PC Davis.
The response in relation to the 1 o'clock is a subjective response whereby we have operators that operate beyond 1 o'clock at different locations on the borough. With a good operator, a premises can work. But with the uniqueness and bespoke aspect of these premises, just to reiterate, the police position is the midnight policy for RBKC. Thank you.
Thank you, PC Davis. Anything?
No, that's it, sir. Thank you so much.
Thank you very much indeed. Any final sweep-ups from the committee? There aren't. In which case, thank you, PC Davis. We're now going to move on to Ms McGann. You have 11 minutes to make your opening statement, and then there'll be questions.
Thank you, Chair. The representation on behalf of the Licensing Authority can be found at page 59 of the initial committee bundle. It's been submitted on the grounds of prevention of crime and disorder, prevention of public nuisance and public safety. The representation was submitted by David Williams, who is unable to attend committee today. As you can see from his representation, he has spent 2 years engaging with previous management of this premises, and I too have spent over 6 months. A list of complaints since September 2020 has been attached to the additional document to this committee report. You can see on this report the complaints made to the council, but there's also been a large number of visits made by officers to the premises. In addition to this, there's numerous meetings and assistance the council has provided the operators during this period. The main concern to the Licensing Authority has to do with this application is that there's no indication of who will be operating the premises, nor what type of business they will be planning to operate. Due to this, we believe the same issues will arise again. Those issues are specifically noise nuisance being caused by shouting and yelling of patrons as they both arrive and depart from the premises, security not encouraging patrons to leave the area quietly and quickly, cars parked in Kensington Court when the owners return to the area, they are disturbing residents of slamming car doors, playing loud music and loitering in the area. Horns from vehicles making loud noises. Patrons congregating outside nearby residential dwellings, shouting, talking and smoking. Also crime and disorder being caused by patrons fighting outside the premises. The above most often occur in the early hours of the morning. As you will be aware, there are 7 representations from residents with regards to this application, and you'll no doubt hear from residents that are here today in regards to what they've experienced over the years. If I could ask the committee members to turn to page 60 of the initial committee bundle, you'll see within the application, within the representation from the Licensing Authority, if the committee are minded to grant the licence, the hours be reduced to midnight. The Licensing Authority have a number of conditions which we've attached as Appendix 2, which I'm sure we will discuss later on. Thank you, Chairman. That's my submission.
Thank you very much, Ms McGann. Let me ask the committee members what questions, if any, they've got. Councillor McVeigh.
Thank you, Mr. Gann, and thank you also to you and Mr. Williams for all the work you've done on this premises over the years, because I know it is a huge amount of work you have done, and you had really tried to support the previous operators and gave them a lot of advice, which sadly I don't think was taken up. But now we are looking at a different proposal, and I know it's very easy to look back and think the patterns could well be repeated, but we have to, as a committee, bear in mind that it's not the same operator. Although obviously it is the same physical location. So I take on board what both you have been saying and PC and Davis has been saying about the location in regards to going round to the parking and everything at Kensington Court, and I'm sure Mr. Mahaffey will say about the actual structure in terms of acoustics. But my question to you really is, with all that in mind, I mean, I'm trying to look at this case as in a twofold thing, one to do with the physicality and the location, and one to do with the operator. Mm-hmm. And without knowing who the operator would be, what would your suggestion be here then? What would you like the committee to do?
Well, that's what's quite difficult for us, because we are not talking about an operator at the premises. We would stay with the midnight policy. If we have operators going into the premises within a midnight licence and operating well, and we know them after a year or two, they could then look to vary their licence to then have a later hour. But at the moment, we're not talking about an operator, we're not talking about any type of clientele. We have no idea what will go into that premises, so we would stick with midnight policy.
Thank you. And just a follow-up question, if I may. Because obviously we've all sat on several shadow licenses, we are all very familiar with shadow licenses in this borough and for nightclubs primarily. If something happened with another nightclub and the landlord had a shadow license, there would then be a period where the landlord would hold that license before another operator came on. So at what stage would the licensing authority have any input on who would be the operator for that said shadow license?
It depends on the circumstances. So if we're talking about this case, I believe that if there was a shadow licence in place, the police would have reviewed that shadow licence alongside the premises licence that was operating. So it would be a very difficult question to answer in regards to this case.
Understood. Thank you. Thank you.
Thanks. So, Ms McGann, your pitch to us is, again, not an outright refusal. It's to apply the midnight policy with conditions. Is that correct?
That is correct.
And same question as to PC Davis, is midnight the terminal hour that you're proposing to us with an earlier cease of alcohol sales, or what are your views on that?
I would say midnight for alcohol sales and 12:30 off the premises.
I'm just making a note there. See if I have any other questions. No, I don't. So let me ask our licensing officer, our solicitor, if she has any questions.
No questions from me, thank you.
Thank you very much indeed. And Mr. Butt, do you have any questions for the licensing authority? Sure. Thanks very much indeed. So just going around the other responsible authorities, PC Davis, any questions?
No questions, thank you.
Thank you very much, Mr. Mahaffey. Thanks very much. And going through the objectors in turn, Ms. Hamilton, do you have any questions? Ms. Rook, do you have any questions? Any questions for licensing? That's a no. Okay. And Mr. Lavelle, any questions for licensing?
No questions from us, sir.
Thank you very much indeed. And Mr. McGann, thank you very much. That's the end of your section. We're now going to turn to noise and nuisance. Mr. Mahaffey, you have 11 minutes to make your opening statement.
Good afternoon, sir. Basically, I'll keep mine very short because you've heard from my colleagues and clearly they've outlined the history of the issues. From the noise and nuisance perspective, there's really two issues. One, containment of sound, and secondly is the external management and the impact that the premises creates on neighbouring residents. And clearly those were the two things that gave rise to the unsafe conditions that arose at the premises for the review to take place. Any new operator who comes into the premises will have to manage those things. In regards to the internal sound, and that is very much a technical fix. My view is that the tenant of the premises should be charged with doing the works to the sound insulation. They will be moving in. They will probably want to refurbish the premises. And when they refurbish the premises, they can probably strip out things that they shouldn't strip out. So I would prefer to have an acoustic consultant on board with the tenant and in league with the landlord to make sure that things are done. And then we can do testing afterwards. Mrs. Rook will give testimony to the impacts of music escape, especially low frequency sound that went into her property and into the property of the neighbouring, of a resident directly below her. It was quite an untenable time for all residents in Kensington Court, which shared a party wall. And clearly this is an ideal opportunity to get that right. So it's very much a case of upgrading the building and then limiting the sound inside the premises to manage the levels that are generated so that we don't have noise transmission across the party wall into neighbouring properties. The second thing really is that when you have people leave the premises, you can control them when they're on the premises, but the minute they walk away, you're not able to exert control on people in the same way as if they're on the premises. So clearly, the later the premises operates, the greater that impact can be on residents. Kensington Court behind is behind the premises. It's rather deceptive because you look at the premises, it's on a busy road, but you don't realise that people go in, they park in Kensington Court, they party in Kensington Court. It's a quiet, reverberant street. There are lots of bedrooms overlooking the street, and there's a lot of residents who can be affected. So if we had a premises operating to 1 o'clock in the morning with everybody leaving, you're basically increasing the disturbance that these residents will impart on the residents, and clearly that would be untenable. It's for that reason I would prefer an earlier finish time, with the premises alcohol sales finishing at midnight and the premises closing to their patrons at midnight, with late night refreshments continuing until when the premises closes. We have asked, as part of my representation, for an external management plan that can hopefully govern the smoking by people outside the premises, and within that they can specify a number of people. If they're reducing the capacity from 250 down to 150 people, you're not going to get a lot of people out at any one time, because not all 150 people will smoke. You'll probably find that maybe a third of them will. And so that would probably be 50 people. Spread over the evening will probably mean that you could have 5 or 6 people outside at any one time. And that would be all part and parcel of the way in which the premises are managed. The door staff are properly trained. And again, that would all be written down in the policies and procedures of the premises to get it right. Liaising with local residents would be key here, because at the end of the day, I think it's always good that residents have the opportunity of feeding into an external management plan and to be able to review it with the premises on a regular basis. And that would be my view on this application. A midnight terminal hour for the sale and supply of alcohol, basically, and the premises closing and everybody gone by midnight. Thank you, sir.
Thank you very much, Mr. Mahaffey. My colleagues, Councillor Healy. Thanks very much. So just my own understanding, alcohol sales at midnight, to stop at midnight, terminal hour at midnight 30,
Yes.
And not an outright refusal.
I would think that the premises, if they operate for a period of time, can come back for a variation. And I think the onus would be on them to prove that they have good management processes and procedures in place for that variation to be granted. But that would be something for the future.
So for today, you're pitching midnight 30 as the terminal hour.
Precisely, yes, sir.
And the conditions, the physical conditions and the dispersal and management plan are part of your requirements as well?
Yes, thank you.
And do those conditions still apply if they certainly still apply with that earlier closing hour then?
I would expect all premises that are operating in the borough to have similar conditions. At the end of the day, we're in a contentious location, residential properties close by, and I think it would be good practice to comply with that condition.
Thank you very much for putting that on the record. And anything? No? Okay. Ms. Limaziri, nothing from you. Let me ask Mr. Butt, any questions? Thanks very much. And we'll go through PC Davis. Any questions?
No questions.
Thanks, Ms. McGann. Ms. Hamilton, any questions from you? Ms. Rock? Thanks. And Mr. Lavelle, anything from yourself? Thanks very much indeed. Mr. Mahaffey, thank you very much for your submissions. That's the end of your section. And we're now going to go through the... Okay. Councillor McVeigh is just sorting out her back. She's still continuing to listen to the hearing, but I'll just make sure you...
Sorry, bad backs, I'm standing up.
Right.
You have my sympathies. I have a bad back as well, and it's not fun.
Okay, so we are going to carry on. So the next section, we're going to go through the objectors in turn with your submissions to us. So this is your opportunities individually to make your statements to us, and then you'll be open to questions. So I'm going to ask Ms. Hamilton to start,
Okay.
please, representing Kensington Court Residents Association.
Yeah, and thank you. I I'm sure you can appreciate that the residents are very sceptical about. We succeeded in getting a licence revoked in the 8th of after the hearing on the 8th of February, and then suddenly there's a new application, you know, just a matter of weeks later. So everybody's very sceptical. We still have the same objections about noise nuisance. I mean, we were promised limiters and all sorts of things. That never happened. Antisocial behaviour, as the licensing people and the police know, you know, resulted in stabbings in the end. And by Mr. Butt's own admission, the landlords say they had no idea all this was going on. But, and you also, Mr. Butt, compared Percy's, you spoke about Percy's. Percy has been there long before Jacob's ever was. It's never given us any problem. It doesn't have a party wall with a residential building. There's no comparison. And you also say that the building, the premises is a basement with no windows or anything, and it would be very difficult to have any other kind of activity there apart from a nightclub. Well, if my memory serves me right, it used to be a Davies wine bar, and there was a restaurant down there. It was a perfectly well-run place, and it gave us no problems at all. It doesn't have to be a nightclub. And even if you say, well, we'll reduce the licensing hour to midnight, people, they'll just ask for more and more, won't they? I mean, that won't stop at midnight. And in the business about no live music, if there's a private function going on, is that all going to be enforced? I mean, I just don't think our residents are confident that anything will move, anything will be any different. And that's really all I came here to say. Thank you.
Thank you very much, Ms Hamilton. And I'm going to ask the committee members if they've got any questions. Okay, well, I have a couple of just... I think I'd quite like to ask individually, because I think you raised the issue of the wine bar, and that's a bit of history to the site that Mr Butt wasn't able to provide because his client isn't here.
Whiskies, it was called.
I think that, but Davies wine bar was before that, I think. I'm talking years ago.
Do you remember roughly when that was and when Jacobs took over and the problem started? Bear in mind I wasn't on the original hearing for Jacobs, unlike my two colleagues.
Well, you know when Jacobs took over.
But it was a bank, and then it changed in 1985.
Right.
And then it was Ruskies, and then it was Utopia, and it was Utopia that asked for the variation of the licence, which I object to and Mr Trim objected to, but that was granted on the 28th of November 2012. Then it became the Kensington Club, but didn't actually operate. Then it was the Hyde, then it was Jacko. Throughout the time, right from Ruskies until Jacko closed, we have complained
Well, Mr. Rook, you've got, because I sense you've started your submission, so your spiel. So, and you would have 11 minutes of it, but you can carry on for a little longer because you've been only going for two or three minutes.
It's just that, really, I have had to write so many letters. Once a licence is granted, it doesn't matter what the conditions are, try and implement them. That the people from Jaco became emboldened because they were untouched. They operated, and I can tell you 100% that's true, frequently, not every day, frequently through lockdown. And we always knew, because their air conditioning is so loud, the moment they play their music, we hear the air conditioning. And on top of that, and perhaps not deliberately, there was somebody called Tito who lived there, and he would often play music in the daytime, not to annoy us, but just to pass the time of day, but we could always hear it. The soundproofing is horrendous. My son's in the Navy. He says, well, warships in battle can have quiet spaces. So I would have thought soundproofing should be sufficient so that the tenants to the rear, and I'm talking about a 6-storey building, where every tenant at the back can hear noise from Jaco. And you're very lucky that it's more people complaining, because next door to us is the Gambia High Commission, and there's no one there in the evenings. So they really don't get the impact of the music. But should anybody ever live there, there'll be a foreign country that will be on your backs. The soundproofing is dreadful, and nobody's mentioned the air conditioning. Every time they turn the air conditioning on, we hear it. I'll shut up now.
No, that's very helpful. Thank you very much, Mr. Rook. So between the two of you, I will ask this question. We have a choice to, first of all, to outright refuse the application that's been given to us, or to grant it with a lower or a lesser hour than was asked. Are you pitching for an outright refusal, or are you saying that what you've heard from our responsible authorities,
Well,
that a midnight close? Let me finish the question first.
Sorry.
So that a midnight closure or midnight 30 would be acceptable. What do you say to that?
I would ask for an outright refusal, because it's just not the size, it's just not the place, it's just unacceptable that we can have all this trouble from a small premises like this.
And what would you put in this place?
Well, it could be a restaurant, it could be anything, it doesn't have to be a nightclub.
Restaurants have alcohol licenses for the most part.
Yeah.
Well, my suggestion would be that Percy's was actually a casino for many years, and we have no casino in Kent. It would be quiet, people would come and go at different times. They could have their whole licence if they wanted it, because you don't get found from buskers music in a casino. So that's what I would say. Or I'm not sure about the cinema in Kensington, whether that's going in or it's closing, but maybe there's a place for even the cinema for it to be used. It wouldn't need loud, huge music. I'll shut up now.
Thank you. Well, obviously, we're interested in a licensing application here, and some of those options are the kind of premises that would have an alcohol license, or would almost certainly have an alcohol license. So a midnight. So you would be, Mr. Rook, for an outright refusal of this, or would you be for an acceptance, but with say a midnight terminal hour or some variation on that? Okay, let me call my colleagues. Councillor McVeigh, please.
Hello, good to see you again. I saw you at the review, so thank you again for your submission for this, both of you, thank you, and for representing the other residents that also objected, so thank you for coming today. We're just trying to kind of understand all sides of this, I suppose, so that's why I think the Chair was just trying to be clear about refusals, and both of you have mentioned restaurants and casinos, both of which would probably also serve alcohol. and we are looking at an alcohol license. So we're not looking at a nightclub license, we're looking at a license to serve alcohol. So we could, as you say, outright refuse it, or we could say we will grant it, but to a lesser hour to enable it to potentially be a wine bar or a restaurant or a casino. Would either of those options be suitable for you if the soundproofing was done, which is a question I raised to the applicant earlier, that the soundproofing is essential, and Mr. Mahaffey says it have to have an independent acoustic consultant to sign off on it, even before it became like a wine bar or a restaurant or anything.
Well, I think we've gone through all this before. I mean, you've had people around for years trying to sort it out, and it just hasn't worked. It hasn't been successful. And it's just been a misery for the people who live on the north side of Kensington Court. Some people have lost their jobs, you know, and it's just totally unacceptable.
So about the soundproofing, I'm sorry, Chair, can I just follow this up a bit? Because this is a big issue, and I'd just like to bring Mr. Mahaffey in on this, because obviously we can put a condition in saying the premises cannot even open its doors until the independent acoustic consultant has signed off on proper soundproofing, not just some guy coming along and putting a bit of plasterboard in, but a proper soundproofing issue. Is that a feasible condition, Mr. Mahaffey? And in your very lengthy experience of the borough, can we get proper soundproofing?
You can, madam. You can. What I would say here is that we're in a very wonderful position whereby, with this condition, we would be asking someone to basically demonstrate to us that they can manage the music levels inside the premises, and we can achieve imperceptibility in a neighbouring property. Now, I would think that if the premises is stripped right back and sound tests are undertaken, we should be able to get a scheme of works that will contain the sound to a certain level, and then we can limit it through a sound limiting device and a design of the sound system to basically ensure that the music, when it is played at its maximum level, will not be perceptible next door. I've seen it happen on many an occasion in a lot of the premises, and I've worked a lot in other premises in the borough to achieve this. And this is no different than anything else that I come across.
So to have a slightly more rigorous condition, because I completely understand what you say about conditions, and I completely empathise with you on that one, it would not be kind of wrong to put a condition on that says the premises cannot actually operate until it has been signed off, the acoustic report has been signed off. Is that correct?
Yes, and I would be very happy to undertake testing at the end of the process to make sure that it is acceptable. And it is really, we would be working with the residents to get it right.
Thank you.
This can all be addressed as part and parcel of the sound insulation works, and clearly we can bring that to the attention of the acoustic consultant, and hopefully you may wish to extend the condition to include the external building services plant as well.
Thanks very much. Any further questions for the two residents? Okay, I'm just going to go around the room and see if any of the responsible authorities have got questions for you, Ms Hamilton, Ms Rourke, and PC Davis.
No questions, Chair.
Mr McGann, Mr Mahaffey, and Mr Butt. Okay, Mr Laval, I'm going to bring to you. You have 11 minutes now to make your submission.
Thank you very much, sir. If I could begin by addressing one of the matters, raised by my learned friend, as to the nature of the representation put forward by Secura Limited. Absolutely, there is a commercial dispute going on between the former tenant and the landlord, who is the applicant in this matter. Both sides have a lot to gain and lose in that dispute, and if it wasn't for that dispute, I would not be here. That does not take away from any of the submissions that I will be making, which are based on your licensing policy, the Licensing Act, and where relevant, case law, sir. And to be clear, the applicant here is not applying for a shadow premises license to protect themselves in the event of something happening in the future. They are attempting to get a new license for this premises to, and it cannot be denied, it will improve their situation. And I would go so far as to suggest it would improve their situation in the commercial dispute they're having with Sakura Limited. And the sums involved in that are not small. The premises was refitted at a cost, my instructions are, of circa £1 million. The landlord, if they gain a new license, would then have an expensively refurbished premises ready to market with their own license. So they have a reason for making this application, and absolutely we have a reason to object to it. However, our objection is founded on the promotion of the licensing objective, sir. If I may very quickly, sir, look through the written submissions of my learned friend solely to identify the suggestion that, as had been put forward, that the new tenant would be approved of by the police. That's neither workable nor appropriate, sir. It's for this committee to have their legitimate concerns addressed by the applicant before granting any premises license. The committee raised the absolutely appropriate question: when a normal shadow license is granted, it could of course be transferred at a later date, and therefore I am merely anticipating that the suggestion was, in this situation, why is it different? Your policy, and I will jump straight to your policy, sir. I won't ask you to turn it up, but effectively, section 18 of your policy deals with shadow licenses. And at paragraph 18.2, your policy states as follows: the usual reason for this would be to protect the freeholder in case the license holder surrenders the license. It also goes on to indicate that the license might be lost by way of review proceedings where they're brought, and that's not informed to the landlord. That is indeed the usual way in which a shadow license is obtained. This license is being applied for post fact, and those facts are that this license was reviewed, and the summary decision of the licensing authority was that the license should be revoked, not amended by way of additional conditions or with reduced hours, but revoked and indeed suspended to ensure no licensable activity takes place here pending any resulting appeal. There is no appeal live at the moment, sir. And so what's being requested is, well, exactly that, a license on amended terms with perhaps amended conditions. This is an attempt to sidestep the very decision made by this licensing authority. And I don't say that's inappropriate or something is possible, but let's look at what's actually being applied for, and it's that very thing. If I then may refer for your pen, sir, paragraph 18.3 of your policy. Applications for shadow licenses will be considered on their own merits, as should all applications. There's no automatic right for the new license to be granted on the same terms and conditions as the existing license. And very importantly, when contemplating their operating schedule, applicants should give due consideration to appropriate steps to promote the licensing objectives and not rely solely on the existing license conditions, as these may be outdated or insufficient. What you see in this application, certainly in the first instance, was it's simply intended to be an exact replication of the existing license. And then you've heard that it is effectively a reduced scope application for shorter hours with some additional conditionality. And what we say is that was not considered acceptable by this licensing authority when considering the review. And therefore, what needs to be done here, as is set out in your policy, sir, is for this committee to consider the application afresh as a new application and ensure that the policy requirements are met. And to that end, I would like to look at the proposal. The proposal now is for a cut-down operation, but it still involves the playing of recorded music until the early hours. And we have to remember the playing of recorded music includes DJ entertainment. That is how nightclubs operate. If there is a suggestion that this will be a restaurant, then it would be appropriate for the commonly used Royal Borough's restaurant condition to be in place, that all sales of alcohol shall be ancillary to the sale of a substantial table meal. That will make it a restaurant. Not the hours, not a last entry condition, but rather the standard restaurant condition. In terms of the hours that are being applied for, they are still outside of the hours policy. And I would suggest paragraph 8.13 of your policy dealing with such states that any exception to the policy, so an exception to a terminal hour of midnight, is only likely to be applied where the applicant can demonstrate that the new or extended licence will not exacerbate the problem, that problem being existing noise, nuisance and disorder within the borough. That has to be dealt with by way of identifying true steps. And I would make this statement that conditions are not proposals. And by way of example, the applicant has put forward the following condition, and this is simply transposed from the previous premises licence. 33, general condition. No music or amplified sound shall be generated within the premises so as to give rise to nuisance within neighbouring dwellings. An admirable condition. That was in place on the licence beforehand. That being in place did not give the previous licensing subcommittee confidence that it would be complied with. And that's because the condition is not the proposal. The condition is the requirement on the licence that should not be breached. But the way to address any legitimate concerns that this committee may have, having heard from the residents and the responsible authorities, would be identifying the proposed way of operating. There is no operator before you to explain to you how a terminal last entry of 11 p.m. will change the demographic of people who turned up. That may or may not be the case, but there's no way your questions cannot be answered. There is no applicant. And whether that's for fair means or foul, my heart goes out to the representative who isn't able to be here because his wife's giving birth, but no one else has been put forward. You are simply confronted with the legal team from the applicant, and they cannot address how it will be operated. And I would suggest even if the applicant were here, as they are not an operator, they have no history of operating, and you cannot inquire as to what ideas they may have, because there's no true operator here, you cannot hear how this license, if granted, would be operated. And to be clear, this license will allow licensable activity to take place in a premises where licensable activity cannot currently take place. The license is suspended. I would also note there's a suggestion that there's a reduction in capacity from 250 to 150 persons. At the moment, there can be 0 persons in that premises engaging in licensable activity. So the application is for an increase of 150 persons who would be able to engage in licensable activity and exit the premises even on the hours put forward by your responsible authority officers. They would be allowed to exit the premises post-midnight, having engaged in licensable activity, and we can hear nothing about how they would be controlled and managed. Again, in line with my submission that conditions are not proposals, Mr. Mahaffey has put forward the requirement for a dispersal and external management plan to be put forward. I think that's an excellent condition. I believe I may have been responsible for the drafting of the first part of that condition. However, when that condition is proposed, it is, in my experience, accompanied by a draft of the proposed plan to address the concerns of the members and the concerns of the officers. Again, we've got an indication here that you are leaping into a void in order to grant this and simply require other elements to take place later on, the selection of an appropriate operator, the production of a management plan, management plan. And I would also note that the proposed condition, because it's intended when it's used by other applicants, including myself, to be accompanied by a draft plan, it doesn't require the sign-off of anybody. It merely requires that it has been produced in consultation with. A draft then ends up in front of the members for their consideration. There's nothing here for you to consider, sir. And so I would suggest that is not quite the check and balance that perhaps you may be requiring in this situation. And with that, I just move on effectively to my final submissions here, so I'm probably running out of time. But those being the nature of the applicant, which is clear for everybody to see, they're a professional landlord. They may be a good landlord, they may be a bad landlord. You may have questions for the landlord as to their involvement in this matter that led up to the revocation, but you are unable to ask any of those questions or have any legitimate concerns you may have answered. Again, whether for fair means or foul, you cannot do that at this hearing, sir, and you cannot have any concerns you may have addressed. In terms of the operating schedule put forward by that applicant, it may have been possible for a detailed and thorough operational management document, for example, to be put forward by the applicant identifying the way in which any future tenant would have to operate. I would submit that's not enough, but it may have been something that would address your concerns, sir. I would suggest really there should have been an operator putting forward their operational management plan. But what would we expect to see in there and what are we not seeing? Staffing structure, security engagement, compliance monitoring. Where there should be information in this application, there's just a blank. And as I've already said, what you see...
I think I need to ask you to wind up at that point, Mr. Lavelle, because you've reached your 11 minutes that you've just gone over by a few seconds.
I'm terribly sorry I've gone over, sir. Well, I will allow me simply to conclude, sir, that this application does not address the issues raised in your policy. It does not provide you with any form of inquiry here at the hearing, and nothing is put forward in terms of a positive approach that identifies how noise nuisance will be prevented or reduced, how crime and disorder will be addressed and produced. And for that reason, we say it is not compliant with your policy. It should be refused in its entirety. If the committee are minded to grant, we would suggest, in terms of bringing it within your policy, a restaurant license where alcohol is required ancillary to the provision of a table meal up until your framework hours, which is a midnight requirement, would be appropriate. However, as I say...
Mr. Lavelle, I think we have now exceeded your allotted opening time, but we have an unlimited time available for questions, and I'm going to turn to the committee.
I do have a question. I'm trying to work out how to phrase it as a question rather than a statement. So if you want to go first.
I do have just one. I mean, do you accept, Mr. Lavelle, that there is a distinction between a premises and an operator, and that the licence that we're considering today is more about the premises than the operator?
So I would accept there's a difference between the premises and the operator. However, as was found in the review, the nature of the operator is fundamental to the promotion of the licensing objectives and the grant of a premises license, unless the premises license were so restricted that any operator could be there without jeopardizing the licensing objectives.
Thanks. That's helpful clarification, Mr. Lavelle. Councillor McVeigh, are you ready to...
You pretty much summed up what I want to say, actually, very succinctly, so thank you.
Thank you. I think that's the committee questions, but let me see if our solicitor has any questions. She does not. And we'll go through the responsible authorities. PC Davis?
No questions, Chair.
Thanks, Ms McGann. Mr Mahaffey?
No questions from me, sir.
And our applicant, Mr Butt? Thanks. And our resident objectors, Ms Hamilton and Mr Roke, do you have any questions? You do not. Thank you very much indeed. So that brings us to the end, Mr Lavelle, of your section. Thank you very much indeed for assisting us there. The next thing we need to go through is the potential conditions. And this is potentially quite a lengthy part of the proceedings, but this is done for the benefit of those who are not quite as familiar with licensing as others. This is done without prejudice to our decision, but we're going to go through with the applicant all the potential conditions, and our solicitor will lead us through that, and I might bring other people in at various stages as we go through it. So, Mr Missouri, if you please go ahead.
Thank you, Chair. Has everybody got a copy of the draft conditions that were circulated? This is what I'm going to be looking at. So I'm primarily addressing the applicant, but obviously if there's anything important, if people could chip in, please. First page. Are you still applying for the seasonal variations non-standard times? Or is that not included anymore?
I think it's obsolete as a result of the changes anyway.
Okay, not applicable, thank you. And also in relation to the 12 occasions per annum, you deal with that by way of tens now if it were to arise in the future, so it's obsolete as well. Thank you. Right, turning to the next page, are you happy that existing conditions 8 and 9 are now obsolete? Thank you. Turning to condition 10, are you happy with the rewording, including the words in square brackets? Thank you. Right, obviously condition 11 is consumed in condition 10, so that's not applicable. 12 and 13 are referred to in later conditions, which I think you've agreed is the case. Same with 14, that's now obsolete as well. So turning to condition 15, this has been requested by the licensing authority and I've slightly tweaked it. Are you happy with the amended wording in red?
The only difficulty would be, obviously, if the license were granted until midnight with a restaurant condition, this would become obsolete.
So if midnight with restaurant condition not applicable.
Can I ask a question? And if midnight without a restaurant condition?
This is a condition that is put on nightclubs. The intention is not to run a nightclub, even if 1 a.m. were granted. We entirely understand why, if the committee were minded to grant 1 a.m. even on Fridays and Saturdays, the committee would want to operate with this. But there would come a point, and it's a matter for the committee's judgment, where if what was being granted was so far away from what could be a cocktail bar and nightclub, this condition would no longer be applicable.
So, sorry, in answer to that question, if it was midnight without the restaurant condition, what was your answer to that? Sorry. Sorry, in answer to Councillor McVie's question, so if midnight was granted but no restaurant condition, what was your answer?
I think we would ask that this apply after midnight.
Okay. Thank you. Okay. Right, turning to 16, including all the bits in red, what's your view on that? I suppose each condition needs to be considered, needs to be answered if it's midnight or if it's 1 o'clock.
I think, again, if the hours are being scaled back to a midnight terminal hour, this condition would not seem to be necessary anymore. But if there were a 1 a.m. licence, it would seem to make more sense.
Okay, thank you. Condition 17? You're happy with that, thank you. Condition 18?
Would you be kind enough to put your microphone on?
It's agreed, thank you very much.
Thank you. Condition 19?
Agreed as well.
Thank you. Condition 20?
Yes, thank you, agreed.
The tweaks to 21?
Agreed, thank you.
22?
Yes, thank you.
23?
So it's subject to the timing of the SI condition that goes beforehand.
Sorry, can you just elaborate on that?
Well, so this is a condition which is contingent upon there being, obviously, SIA door staff. So depending upon what's agreed in relation to the timing of the previous condition,
Okay.
of course, those who are working, but the time would need to match.
24?
Yes, thank you.
25, that's our standard condition.
Yes, thank you.
26 has been dealt with in 25. 27, no promoted events.
That's agreed, thank you.
I do just want to clarify this, because promoted events are a many-headed monster in many ways and can be incredibly beneficial to many businesses. So it's a promoted event, you know, I mean, probably more of a question for the licensing authority. I would be nervous about putting such a blanket condition on a license without specifics. I just don't see how that's enforceable, and going to the point of the residents saying enforceable or not.
Let's see what licensing have to say about that.
That's better. I think these conditions were suggested, a number of them, when we were put forward with the 3 AM licence. I think they're conditions that we recommended in the previous hearing and that were applicable with the 3 AM application that came through to us with the new grant. So perhaps it wouldn't be so applicable if it was a midnight licence.
Thank you for clarifying.
But Mr. Butt, you in principle you're agreeing with it, and obviously I recognise that an application to amend a licence can come forward in future at any stage.
I suppose I wonder why 27 is being replaced with no promoted events. So the existing condition 27 was the standard one exercising control over them. The proposed replacement is no promoted events. If it were to remain as per existing condition 27, then it would remove the concern Councillor McVeigh raised about, well, promoted events could apply so widely.
Sorry, if I can just come in there. I
Ms.
don't know
McGowan.
if police might want to speak, but there's no 696 form. This is an old condition, and I believe we're not able to risk assess people doing promoted events. That's why we had issues with this condition enforcing it in the first place. I don't know if there's anything else you'd like to say.
Ms. McGowan, does this also, were we minded to put in a midnight time as was your pitch to us, would this condition still be something you'd be pitching for, or was it less important?
No, this isn't something we wouldn't think this would be an issue if there was a midnight licence at the premises.
So this is really only for a post-midnight?
It's a late night venue condition.
Yeah.
It's about promoted events.
Okay. If we heard, let me just turn to the committee and see if we've heard enough of that discussion to have a discussion. Thank you. Let's move on.
Thank you. Moving on to 28. That's just a slight tweak. Are you happy with that?
It specifies from midnight onwards, so that would be
Fine.
it's 29.
And 29, obviously subject to the midnight. Okay. 30, slight
Thank you.
tweak.
Yeah,
31,
is agreed.
32, are you happy with the words in red? Subject to, obviously, the midnight.
Again, it really depends upon the decision the committee comes to. If it were to be a licence permitting 1 AM, even only on Fridays and Saturdays, then one can see how this condition could be relevant. If it were a different kind of licence, the committee probably would take the view this was not necessary, but
Thank you. There's no change to 33. and 34 apart from just typos. Same for 35 and 36. I presume you're okay with them. 37 again, I put C also condition 49, but obviously it's subject to what the committee decide. But are you happy with that in principle?
As it's from midnight, it would comply.
Okay. 38 with the extra words in red.
If it's the borough's standard condition, then of course we're not going to quibble with it.
Yeah.
Thank you.
Yes, thank you. So going to 39, this is obviously the one that's been discussed. Alcohol shall only be sold by waiter waitress service for consumption to customers seated at tables throughout the licensed area, except that alcohol may be sold or consumed ancillary to table meals, subject to those two provisos. You're happy with those provisos in. I think a plan needs to be updated showing the bar area. And in your additional submissions, you've provided a definition of what private function is. Does anybody have any views on condition 39 at all?
Could I just say on that, sir? Oh, sorry.
Yeah, I would start with Mr. Butt and then we'll come round the room for...
Obviously, condition 39 is central to our proposal as to how these premises can trade. So we would ask that condition 39 be granted, be issued, and updated plans would need to be agreed. And the wording that we have used for a private function incorporated.
But you're happy with the rest of the wording?
Yes, thank you.
So as this is very important, let me go to the police, if you've got any comments. Licensing, noise and nuisance, anything you want to say on this one?
I think, again, as long as it's to the midnight policy, it is it's a position for the police in relation to this condition.
Thank you.
Mr. Lavelle,
Yep. And then Mr. Lavelle has commented, and I'll go to the other objectors, see if they have anything.
Thank you,
on
sir. Just to quote this, just to be clear, this isn't, of course, a restaurant condition. Everyone may be aware of this, but I simply make the submission. This is a condition for a seated bar. Alcohol shall only be sold by waiter-waitress service for consumption to customers seated at tables throughout the licensed area. In fact, you can end there. You don't have to be eating amongst that. It's a effectively 100-person seated, 150-person seated bar under the current proposal. It also notes that alcohol may be sold and consumed ancillary to table meals to people standing in the designated bar area, and as we know, the plan submitted with the application isn't sufficient to allow that to be identified. And then it also states up to a maximum of 150 persons standing at any one time at a private function. Again, that consumption, although while standing, must still be ancillary to table meals, perhaps later in the day. But to be clear, this is not a restaurant condition. You do not have to eat food to be sat in this premises. So up until midnight, under this condition, 150 people can drink without eating, so long as they are seated. They can then all leave at midnight, midnight 30, whatever terminal hour this committee decides on. And so in my submissions, the requirement for a restaurant condition would identify that alcohol shall only be sold by waiter-waitress service for consumption to customers seated at tables throughout the licensed area and ancillary to the commensurate sale and consumption of a substantial table meal, if indeed this committee were minded to make it a true restaurant condition, sir.
Thank you. So noted that you're pitching for a restaurant condition, and we've noted that Mr. Butt has accepted what's written here, which is not a restaurant condition.
it is a highly restrictive condition on any view, and so you've heard the respective submissions about what ought to be granted.
Thank you very much indeed. That's helpful, and I think we can move on unless anybody else...
So could I just clarify, although you're quite right, I was suggesting a restaurant condition would be appropriate, but that's, of course, if you're minded to grant. Our position is that a licence should not be granted.
Of course, and this entire discussion, as I made clear at the beginning, is without prejudice to our decision, our overall decision, but we do have to go through the potential conditions, because if we get to the point in our discussions where we've decided to grant and we're left having to come back and resume to go through the conditions. So
absolutely, so no objection from me on that. That's best practice.
Please proceed, Mr. Nazarian.
Thank you. 40, that was an existing condition, no change. I presume you haven't got any comments on that?
Again, we would suggest this is likely to be something that is only relevant if the premises are open after midnight.
Just bear with me. So 41, 42, 43, and I think I've deleted 44. Are you still seeking the inclusion of these conditions?
They're highly unusual conditions. They've clearly, historically, been put on for a reason. They could certainly only apply if it were a late-night bar-style operation. I don't know whether they are perceived to be conditions that promote the licensing objectives sitting here today. We would submit they are unlikely to do so.
Yeah, so you'd rather them removed?
Yes.
Okay. Yeah. Anybody else have any comments on that one? Okay, thank you. Right, okay, so going on to, just bear with me. Sorry. 45, there's no change, unless you've got any comments on that. 46, I think you've suggested 2,300 hours. 2,300 hours here.
And again, that would be on the basis that they were a license until 1 a.m. If we were within framework hours at midnight, then that would be an nonsensical condition.
Okay, thank you. 47, this is the drinking up condition. Are you happy with 30 minutes?
Yes, thank you very much.
48, again, obviously, I presume this obviously depends upon...
It falls away on any view, doesn't it? Because no one's asking for beyond 2.
49...
would depend upon whether the licence were granted beyond midnight.
Okay, so if up to 1 a.m, then okay, if not, no. 50 with the extra words.
Thank you.
Sir, sorry, could I just make a comment on that?
Yeah,
Mr. Lavelle, 49.
Just going back to 49, the very nature of it is that it's there to ensure that it states to encourage persons to leave quietly and assist them with their travel arrangements. If the premises closes at midnight, people will be leaving, and it may be that they're required to be assisted leaving quietly, and that is perceived by this condition. I simply make that observation. People leaving at midnight or midnight 30, depending on if you are minded to grant what terminology you're looking at, can cause a noise nuisance, and this envisages, admittedly it says 3 SIA, that may be excessive, but it's envisaged that there will be people there to wish them on their way and ask them to do so quietly.
Thank you, Mr. Lavelle. Mr. Butt, do you have any comments on that?
Mr. Lavelle's only interest in making these submissions is to put conditions on the licence that are expensive for the premises licence holder in order to procure a commercial advantage for his client. Now, he can make those points, but I would ask the committee just consider how much weight they give to those submissions. If the licence were granted until 1 a.m. with a 1:30 off the premises hour, then we would agree that given the nature of the premises and the location, this would be a reasonable condition. If, however, it were within framework hours, we would submit this condition would no longer be necessary on the licence.
Thank you both. I think we've heard enough to make a decision on this, and I just want to move on and focus on the conditions.
Thank you, Chair.
Thank you.
50, I think, were you okay with the
Thank
words
you,
of it? 51 was removed because it's in condition 34. 52, now, I think are you happy with this condition? I know Mr Mahaffey mentioned it could be subsumed into an external management plan, but are you otherwise happy with this condition?
Sorry, can I just come in on that one? So I think there's an error here. I think this was in regards to when the area was being used, which shouldn't have been used. The fire exit, there's a number of 15 people. If we're now saying the area needs to be on the Kensington High Street, 15 people would not be possible.
What would you consider acceptable?
I don't know how many people could squeeze within a small area of busy Kensington High Street. It's the main highway.
And actually say that I think that this condition is subsumed already and covered in 46, and as you say, it's not relevant now. 46 is right. You can always limit that to 5 or 6. That makes sense. You look at condition 46, it talks about smoking in the rear.
Yeah.
And then we can add into that if we were minded to grant the condition about classes. But we'll discuss that.
I think we've got enough to discuss that now. I think that'll be our decision now.
Thank you. No change to 53. I think 54 relates back to the smoking again.
We'll have to tidy all this
We've
up.
got to tidy
Yeah.
this, we need them.
No change to 55. No change to 56. I think 57 was put into condition 17. Now we're going to the police conditions, which in my numbers, we've already discussed that in condition 39. 59 we've already discussed in condition 19. Same for 60, 61, 62. Turning to 63, this is a standard condition. Can I have your comments on that, please?
It's agreed. Thank you very much.
Thank you. And 64 that's subsumed into condition 38 by the looks of things. And 65 is in 67 below. Then we'll jump, so the licensing authority request has been subsumed into the noise and nuisance condition. So going to number 67, this is the dispersal and external management plan. Can I have your views on that, please? Thank you. 68.
I just want to jump in here. Sorry, 68. If the committee were minded to agree, goes back to what I've been going on for the last 2 hours about soundproofing, proper soundproofing, and I'm not happy just to have that just as a condition of operation, but a condition of actually opening.
Prerequisite condition.
So we will be discussing that.
I don't think I'm being asked to.
You're not being asked. Sorry.
In any event, it would be agreed.
Thank you.
Thank you. 69.
Thank you.
70. Oh, sorry, that's in number 50 above, sorry, I beg your pardon. 71.
Yes, agreed. Thank you.
Turning to additional conditions, that's not applicable anymore because you're not...
72 would fall away, no off
yeah,
sales.
so there's no off sales now. 73. Is that dependent
Yes,
on...
I think that would be an important condition to ensure 39 could be enforced if the committee were minded to grant a condition similar to that formulation.
Okay. 74.
Yes, thank you.
I've just got another couple of conditions which I thought of as we were going along. This is what we generally put on shadow type or new licences in this type of scenario. This premises licence shall have no effect until such time as the existing licence for 1A Kensington High Street, the JCO licence, has been revoked, surrendered, or if the lease of the premises has been subject to forfeiture proceedings by the landlord. Are you happy with that kind of condition? Sorry? Yes, thank you. And
I think we've got a comment from Mr. Lavelle.
sorry.
Sorry, so we didn't hear that.
Sorry, I'll repeat that again. Sorry, I beg your pardon. This premises licence shall have no effect until such time as the existing licence for 1A Kensington High Street, that's your licence, has been revoked, surrendered, or if the lease of the premises has been subject to forfeiture proceedings by the landlord.
I would just note that that condition is of very questionable value. The forfeiture proceedings have already been instigated by the landlord.
Okay. Would
So
you
this licence
suggest any
immediately comes
wording?
into effect.
So would you suggest any tweaks to that wording then?
Simply removing that section. If the members are minded that they don't want two licenses to exist at once, removing the ability for the applicant to simply fall back on something they've already done would perhaps deal with it. So I would suggest, simply the removal of the reference to forfeiture proceedings would probably achieve what the members are hoping it would.
Thank you for that. Let me just ask Mr. Butt if he wants to.
We would obviously ask that subject to forfeiture proceedings remain. The whole reason for that being on a licence of this kind is to enable the landlord, if they take eviction proceedings against the tenant, to be able to trade under the new licence. The appeal of the revocation could continue for some time if such an appeal is brought. So plainly, it ought to be in those terms, because it might be the case that the forfeiture proceedings are the manner in which control is regained by the landlord.
I'll bring Mr. Lavelle in one more.
My learned friend seems happy enough to cast aspersions on my submissions. Forfeiture proceedings have begun being commenced. Relief from forfeiture has been applied for, but that tenancy is at an end. So this condition triggers the moment the licence is granted. I don't see how my learned friend could make any submissions other than to identify that this condition, if it's on the licence, has nil effect, because those steps have already been taken. Okay, my instructions are very clear on this, and that's one of the reasons we're here, that forfeiture proceedings have already been taken and effectively completed by the landlord. That's why a relief from forfeiture application has been lodged at the court. So my learned friend can say that those things don't apply, but they do. They're in the wording of his proposed condition. And it's a condition that will trigger the moment the licence is granted, in my respectful submission, sir.
Thank you, Mr. Lavelle. Mr. Butt, one more chance to come back.
That's absolutely the point. This is not my proposed wording. This is a standard wording in a condition of this kind, that it takes effect either when the licence is surrendered, therefore the person originally trading can't use it, or revoked so they can't use it, or forfeiture proceedings are brought so they are no longer going to be in occupation of the premises. The fact that that has happened already is in no way an obstacle from this condition being imposed. Otherwise, we'd had the farcical situation that the previous tenants would be able to prevent the premises from trading simply by keeping their appeal alive when they no longer had a landlord and tenant connection to the premises. That's exactly why there must be those three terms within the condition.
Okay. I think we've heard enough to have a discussion about. So, Councillor McVeigh, do you want to come and ask her?
I've just got to jump in here because this condition has been proposed by our excellent solicitor, and I didn't notice that you've proposed it.
As I said, it's not our proposal. It's not.
It's not on your
proposal. It's the standard condition that is put on shadow licenses.
So if it's so crucial, why did you not put it forward?
Because what's crucial is the third part. If the condition comes on and says it shall not take effect until 1, 2, or 3, we would require the third. If there's no condition on the licence, it wouldn't be a difficulty. So it's if the condition is there, it must be the standard condition.
Thank you for clarifying that. Thank you.
All right. I think we've heard enough to have our discussion about this, and obviously we're going to have to resolve this.
I'm sorry, if I could just make one final submission. The concept of this being the standard condition, there's no such thing. It may be the condition that this borough prefers to place on licences, and I'm happy if that's the submission. I'm happy if your legal advisor identifies it's the condition she prefers to put on. All of those things are fine. There is no standard condition for a shadow licence. Just to be clear on that. Thank you, sir.
Thank you very much. Mr. Mazieri, you had a 75 as well to go through.
76, actually.
Oh, sorry, that was 75. I apologise.
We don't have an existing capacity limit on the licence, but I noticed you proposed a capacity limit. Are you happy to a maximum of 150 people, including staff and performers, shall be present on the premises at any time?
The condition that we proposed in my submission was that 150 customers, so that would be in addition to staff. And I would just ask the committee consider whether that is a condition they would impose if the licence traded beyond midnight, or if that was a condition they thought suitable for any licence. And I say no more than that.
Okay.
Thank you.
I think that was it. Sorry, yeah, far
Yes,
away.
that's,
So I just, I'm just going to ask one question. Are there doors at the rear of the premises? Is there any issues with the doors apart from like the front doors that need to be addressed at all?
Are we, Mr. Rook, Mrs. Rook, are you looking at this one entrance here? Yeah.
Yeah.
So where is it?
Okay, I think we need to just come to order here and
Can I suggest that this will be dealt with by the condition proposed by Mr. Mahaffey, condition 1. The premises shall not reopen and operate under the terms of this premises licence until a dispersal and external management plan shall have been submitted to the Royal Borough and approved.
yeah, Councillor Bavay.
Sorry, knowing what Mrs. Rook is trying to get to, you're talking about the back, aren't you?
Yes.
The back lobby, so it's nothing to do with the external dispersal management policy, it's to do with probably more the soundproofing and the use of those areas, which I believe, I might be wrong, but is this back area here which really affects it?
So I think we can, yeah, I mean, this is a very important point, and I think we can incorporate this. Let me bring Mr. Mahaffey in the external management plan, or the dispersal and external management plan. Well, external includes all the doors to the club, including the fire exits, does it not? So can we incorporate this point?
Sir, what I would recommend is that there should be a condition on to say that the rear basement external doors shall be kept closed at all times. Live licensable activities take place on the premises. And I think that would do it. As part of the acoustical works, that door will be upgraded acoustically to ensure that the sound will not escape the building through that door.
So something along the lines of the rear exits to be closed at all times apart from in use for real emergencies. Mr. Butt, does that, with a bit of tidying
I
up,
think
sound
it's also
reasonable?
required for access and for use by staff. And that's why the proposed condition at page 66 from Mr. Mahaffey is absolutely designed to deal with this. It's dispersal and external management. Detail the procedures, management controls and practical steps, including all measures to control any noise generated by members of the public, employees, delivery drivers, entering or leaving the premises. So there will be a plan that will be agreed. It will be prescriptive in terms of the use of the rear of the premises, and a breach of that plan would be a breach of the conditions of the licence.
Thank you for that submission. I think we've got enough to discuss that, unless Mr. Mahaffey wants to come back to us.
Sir, I would take the view that the rear of the premises is not part of the dispersal of the premises. So
Okay.
it wouldn't actually be part and parcel of the dispersal management
Yeah.
plan. For that reason, I would prefer a separate condition to basically say that that door should be kept closed at all times licensable activities that are taking place on the premises.
The condition is not in any way limited to dispersal. It's absolutely clear it relates to also external management and staff coming and going. I think it's difficult. Sorry.
Councillor McVeigh.
Jump in here, sorry, because I've been on so many hearings where we have backdoor issues, and we have to probably have a separate condition, and also partly because also the dispersal plan, with the best will in the world, is only submitted to the licensing authority. There's no condition necessarily for it to actually to come before a committee again to be approved. So I think, anyway, we'll discuss this in closed session, but thank you for your input, I think.
Can I simply ask that if a condition is imposed, consideration be given to access egress in addition to emergencies? That's all I ask, but certainly being closed during regulated entertainment, anything of that nature, and we have heard the points that have been raised about it banging, that needs to be resolved and conditioned.
Thank you very much indeed. And did you have you're done, right?
Finished now,
And
thanks.
Councillor McVeigh, I think you had one to talk about as well.
Sorry to prolong this. I know we're all probably desperate to get out of here, but just a quick question, which is going back to what has been discussed many times, which was the police condition, or the not the police condition, but your condition suggesting that the police approve the new tenant. I do think we need to somehow put something along those lines as a condition. We'll probably have to discuss it in closed session, taking legal advice. But that just for record, this has been brought up in front of the committee, so if we were minded to grant it, we would have to put in something along those lines, I think.
I just say, as we are prepared to allow approval, anything that involves engagement, liaison, consultation, it goes without saying, of course, we would agree to.
Thank you very much. So that concludes going through the conditions. I'll ask our legal officer if there's anything further from her.
Nothing further from me.
Mr. Phelan, anything further from licensing? Thanks very much, in which case that concludes the hearing. We will retire to make our decision, and we'll notify parties within 5 working days of our outline decision, and the full determination will follow in due course. But I'd just like to thank all parties for attending this afternoon, and Council and others for assisting us. And I will wish you all a good afternoon, and the broadcast and recording can now stop. Thank you very much indeed.